Well, let's go ahead and begin the final part of the chapter. That would be the part on the rights of the accused. The rights of the accused are outlined starting on page 93, 94, 95. As you'll see in some of the videos you'll watch on the map versus Ohio case, these involve Fourth, Fifth, and Sixth Amendment rights. And they've been incorporated to apply to the states through cases like Map versus Ohio, Miranda versus Arizona. The 40s, 50s, and 60s and early 70s were a period where the Supreme Court rapidly applied the Fourth, Fifth, and Sixth to the states in a very liberal way and bound the states to observe certain constitutional procedurals. All this is procedural due process, really. And they started off with the stuff in I guess, with the Sixth Amendment and talked about it in Gideon versus Wainwright. But let's go through them one at a time with the Fourth Amendment, talk about the exclusionary rule and Miranda. The Fourth Amendment, as you can see on the bottom of page 93, for some of you criminal justice majors, you know what this one is. It protects you from unreasonable searches and seizures, but as we saw at the end of the last section on privacy, boy, the government sure does know a lot about us, and so do the big tech corporations. Um, they're not supposed to search your home unless they have a warrant, and they can only get a warrant if they have probable cause. They cannot arrest you unless they have probable cause. And I must admit, seeing these riots with BLM and Antifa, I'm surprised the police aren't more aggressive, because they sure do have, in my mind, probable cause to arrest these lawbreakers. But nevertheless, uh, they are supposed to search these people for guns, weapons, and they have been finding people with guns and weapons. So these are the basic rights outlined in the Fourth Amendment, that you're free from unreasonable searches and seizures, and there must be a warrant issued by a judge before they search your home. And it must specifically declare what is to be searched and what is to be seized. And as we found out in the Map versus Ohio, you'll see that in the discussion. They can't include things and get you on one thing when they were really searching for another thing. But more about that in a moment. Now, the Fifth Amendment is a major amendment, because this is the one that the guys who wrote the 14th lifted the language from, and they put into the 14th. This is the one that says no person shall be deprived of life, liberty, or property without due process of law. So the founding fathers, Madison and others, they wrote that into this Fifth Amendment in 1789, introduced it in Congress, and it was passed as part of the first 10 by the three-fourths of the states back in 1791. It also prohibits double jeopardy, which means you cannot be tried for the same crime in the same court after being found innocent. And there's provisions against self-incrimination. You cannot be forced to testify against yourself. You cannot be compelled. That's why you have the right to remain silent. The Sixth Amendment, this is a guarantee of a speedy, public, and a trial by a jury, and the right to confront your witnesses. That's an important right. You have the right to be confronted with people that are testifying against you. I can remember being exposed to this in an old Star Trek episode where Captain Kirk was being accused of negligence, and the witness against him, in part, was a computer, of all things. This was a series which was on TV 50 years ago, and amazingly, it took that right very seriously, that you do have the right to confront your witnesses, the witnesses against you. And you have the right to compel witnesses in your favor as well. And the final thing, and this is important, and this is the Gideon case, Gideon versus Wainwright, which you'll see in the videos there, the discussion about that one. You do have the right to counsel at various stages of criminal proceedings. Some judges don't believe you should have, but some judges believe, yeah, you should have it at every proceeding. Now, what is the exclusionary rule? Okay, the exclusionary rule. Oh, the eighth. I apologize. One more. The Eighth Amendment. This prohibits excessive bail, fines, and cruel and unusual. It doesn't prohibit the death penalty, because the government can take your life as long as they provide you due process of law. Now, that's come to mean different things. So now states lethally inject. And since 1976, we've had quite a few executions, although they've been steadily declining in the last 20 years. There was a moratorium for about 10 years after a case in Furman versus Georgia, but by the 1970s, there were some executions, and it rapidly increased in the 1980s and 1990s, when the crime actually really took a nosedive. Okay, now to the illegally obtained evidence. It is not admissible. It is excluded from trial at the federal level since 1914 and at the state level since the 1961 Mapp versus Ohio case, which you'll see in the video. Now, in 2014, interestingly enough, the courts made a ruling that searching the digital contents of your cell phone during an arrest is unconstitutional unless law enforcement has a search warrant. So modern cell phones are that has your personal information. Courts have recognized this, but big tech companies haven't yet. Now, Miranda happened because of this case. Many states already had been reading people their rights. You'll see this in the video on Ernesto Miranda and so on. He gave a statement. Yes, he raped a woman, and gave it coherently, wrote it down. You'll see that in the video. Signed it. He felt he was not pressured at the time. But the attorney took his case and felt that he hadn't been fully informed of his right to remain silent, to not incriminate himself. And he took it to the Supreme Court, and by 1966, the decision Miranda versus Arizona, which overturned his conviction, and he was tried again and subsequently put in prison using different evidence. But if you're arrested, you do not have to confess. You do have the right to remain silent, and government must inform you of those constitutional rights. Now, since Miranda, though, what you can see is violent crime clearance rates, which were fairly stable from 1950 to 1965, generally were above 60%, which is a good clearance rate. Clearance means the case is solved. And they even increased from 62 to 65. But in the 3 years following Miranda, unfortunately, what you see is the success rates of getting violent criminals, murder, rape, arson, fell dramatically to 55% in 66, and to 51% in 67, 47% in 68. And violent crime clearance rates have hovered around 45% ever since. So there's a suggestion in the data, which this was produced by, let me see if I have the notes, by a very famous study done And his conclusion, and you'll see this in the video on Miranda, is that it reduced our success in dealing with violent crime dramatically. Now, nowadays, there's no need as much for all this Miranda stuff because law enforcement's been using a lot of techniques to digitally record interrogations, confessions, and it helps save time and money, creates valuable evidence. You've see them on TV. These people, they just can't help themselves. They start speaking. So it does make it difficult for defense attorneys to claim illegal coercing of their clients when we're just talking, So, how was your evening? What were you doing? And then people just love to talk about themselves, and so it ends up hurting them. So the best thing to say is don't say anything. Um, if you are questioned, to make sure that you just remain silent and you make it clear, crystal clear, you want an attorney. And you just don't say, I want an attorney. You have to make it crystal clear to them, to the police, to an executive branch. So, yeah, there's a lot of crazy stuff out there about privacy versus secret searches right now. Well, guys, so I would study the the stuff at the back of the chapter. That's helpful. These questions here, and again, the key terms on the side bars. And make sure you get those cases in. You'll do 3 or 4 this week, and so that'll be the focus of what you'll need to do this week. And also do that paper on First Amendment freedoms. And I think that's about it. And I'll conclude by saying I will be taping the lecture for chapter number 5. I'll be putting that up very shortly. And if you have any questions, let me know. And keep up the communication. I appreciate the comments and feedback. And if you need more feedback as to what you're responsible for, let me know. Email me. And I'll see you later.